offices.
All right, Robert Maurer. Your
Judge,
client, Jerry Alvarez, is here.
Yes, ma'am. And I think, Judge, I think we can handle it pretty quickly. It's an allegation of not returning phone calls from pretrial, but my client said he actually talked to them last week, and I don't believe a whole lot that comes out of pretrial.
Well, we will see what happens. I believe pretrial will be here to answer because no one knows what Mr. Alvarez has been here, and his pretrial officer is actually here. Ms. Daniels?
Yes, I'm his
Yes.
pretrial officer.
So they haven't been able to get in contact with Mr. Alvarez?
In Galveston?
No, actually, I was able to get in contact with him the same day that I submitted the violation. He ended up reporting to the office.
All right. So, Mr. Alvarez, can you unmute yourself, please?
Hello.
All right. Hi, Mr. Alvarez.
Yes, ma'am.
We're here because you haven't been staying in contact with pretrial services. Now, what I can tell you, what I do in this courtroom is that I will set pretrial hearings for violation reports. And so that's why you're here today, because of a violation report. So
Yes,
you
ma'am.
need to stay in contact with your pretrial services officer. Do you understand?
Yes, ma'am.
All right. So when you were on here before, the phone you were using is not your own. Have you given good contact information to pretrial services so they can know how to locate you?
Yes.
All right, Ms. Daniels, do you have all the contact information to be able to locate Mr. Alvarez?
Yes, ma'am.
All right, is there?
I would like to.
Yes, Mr. Alvarez, your attorney would like your contact information. So after I finish speaking to you, I'm going to send you to a breakout room with your attorney to give him all of your contact information. It's very important, Mr. Alvarez, that you stay in contact with people because this is your first violation report. If I have another violation report where people are not contacting you or able to contact you, we're going to have issues. You understand?
Yes, ma'am.
Okay.
I'm gonna get me a phone after we get off this. I'm gonna go ahead and go get me a phone.
All right. Well, you know, phones now are very expensive. I can't believe cell phones are going for $1,500. I'm like, really? Cell phone is now, you know, what it costs to purchase a vehicle out of the nickel ad. I know some of you too young to remember nickel ads, but yeah. All right. I'm going to then, Ms. Daniels, do you have addresses and everything for him?
Yes, I do.
All right. So then what I'm going to do, I'm going to send you into a breakout room with your attorney, Mr. Alvarez, and then you will be excused.
Judge, can I talk to Michelle first in our breakout room?
All right. Michelle, if you could go to breakout room number 2, please. And Robert Maurer, I will send you to number 2. And Ms. Daniels, you are excused. Thank you for promptly coming in. I appreciate it.
Of course. Thank you so much.
You're welcome. And Mr. Alvarez, do not leave this Zoom. Do you understand? We're not done with your case yet.
Yes, ma'am.
All right. And then the parties on Christian Reyna. The court has all the documents and is ready to proceed with your plea. Do we have a prosecutor available?
I am Judge.
All right, thank you. All right, the court is going to call 2021 CR 9092W, State of Texas versus Christian Escobar Reyna. Can I have parties announced for the record for the state,
Meredith McIntyre for the state.
for the defense?
Michael Samora for Mr. Reyna.
Fine, not this, but the actual.
Just one moment. Where is the extra noise coming from? All right, everyone who's not a part of this hearing, please make sure you're on mute. And are you Christian Reyna?
Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Reyna, I'm going to show you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Judge.
The court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, I have.
The court will find that the state is in compliance with discovery. Mr. Rainey, I'm going to show you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, Your Honor.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict this case and hold you over for trial? Did you understand?
Yes, Your Honor.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, I do.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am, I do.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm showing you what's entitled Information. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
Yes, we do.
State, are you proceeding on the information as presented?
Yes, Judge.
Mr. Rainey, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Do you understand what you're charged with by information is possession of a controlled substance, penalty group 1, 1 gram to 4 grams? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Off the record for a moment. Mr. Jimenez, I'm going to send you to breakout room number 3 to confer with Mr. Crew.
Okay, Judge, I don't think that's going to be necessary unless you wish it.
No,
Because
I understand, but usually what ends up happening
Okay.
is a defendant is going to want to speak to you.
Okay, no problem, Judge.
No problem, but after you finish speaking with him and let him know what's going on, then make sure he comes back to the main room and then we'll handle it from there. And Mr. Crew, if you'll go to breakout room number 3, please. Thank you. We're back on the record. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor, I do.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor, I do.
Counsel, has your client been able to provide you with any defenses to this offense?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Reyna, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes. Yes, ma'am.
According to the plea bargain agreement, there's a $1,000 fine to be probated. State recommends deferred adjudication. State will take in consideration NIATMAG number 617067, 617068, County Court Cause number 651269, and 2020 CR 5073. There's to be no harmful or injurious contact with Leo Reyna and Victoria Lopez. Is there any restitution for drug testing?
There is, Judge. I forgot to put it on the paperwork.
All right, Mr. Reyna, do you understand that there's to be restitution for drug testing?
Yes, Your Honor, I understand.
Any objections to restitution for drug testing being added, defense?
No, Your Honor.
Then, Mr. Reyna, do you understand that to be the entirety of your plea bargain agreement?
Yes, Your Honor.
Defense, is that the agreement?
Yes, it is.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm going to show you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication before a term of 5 years, there be a TAP evaluation, 120 hours of community service restitution, the BIPP course, anger management, intensive outpatient treatment, regular UAs, and parenting classes if applicable. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the information, how do you plead? Guilty, not guilty, or no contest?
No contest, Judge.
State, any evidence to support the defendant's plea?
State offers State's Exhibit 1 and all attachments.
Any objections?
No. No objection, Your Honor.
Mr. Rainey, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes.
Anything you
Well,
wish, yes, anything you wish to say on behalf of your client?
no, Your Honor.
All right, Mr. Reyna, do you have any children?
Yes, ma'am. I got 2,
What are their ages?
7 months and 5 years.
All right, and are the mothers the same of each child?
No, different moms.
Okay, how old are you?
I'm 27, Judge.
Okay, so what is your relationship with the person in this case?
She was my girlfriend at the time.
Mhm. So, and you knew she was pregnant at the time, correct?
She said she was pregnant, Judge.
Your Honor, she also gave a contradicting statement. She is pregnant now, but she also made a statement during a CPS investigation that indicated that she wasn't pregnant at the time of the event.
Okay. So this child, this 7-month-old, is this her child and your child?
Yes, my daughter, Sophia. That's ours, yes.
So is there a child protective services case going on?
Yes, ma'am.
All right, who's your child protective services attorney?
I'm not sure right now. The attorney, I don't remember her name, but I have the paperwork here if you want.
No. I'm asking you these questions because let me just tell you, your child protective services attorney, if you are truly interested in being in your child's life, needs to be on speed dial and you need to know their name because
Yes, ma'am.
that's very important, right?
Right.
So what do they have you doing in child protective services?
Well, I just saw them. Well, I saw them like 3 days ago, and they gave me the family plan, which involves drug testing. It involves classes, parenting classes. That's pretty much it.
All right, if you're drug tested today, what are the results going to be? And before you answer, marijuana is a drug. Alcohol is a drug. When you're on deferred adjudication, you're not going to be allowed to smoke marijuana or do alcohol. So before I send you for a drug test, just be honest with me, because here's the thing. Everyone in their life is on a journey. I call it life's journey. And hopefully, as we age, we learn things and we do better. The key is when you know better, you do better. So we're starting at this point. I need you to be honest with me so I can figure out what services to give you. So if you're drug tested today, what are the results going to be?
I'm clean, Judge.
When's the last time you used?
Which is the day I was arrested, which is June the 2nd.
Your
And when you
Honor,
yes.
I was informed during our conversation there may be some residual THC metabolites.
So when's the last time you used marijuana?
Probably like about 3 weeks ago.
All right. And so you have a 7-month-old child, which tells me when you were using marijuana, your child was with us on the planet in existence. So let me just tell you, a child deserves a parent who's going to be clean and sober. Do you understand? Children don't get to choose their parents. If they did, there probably wouldn't be a lot of parents walking around. I'm telling you truth. The other truth I'm going to tell you, I can't stop people from having children. People want to be fruitful and multiply. I have no jurisdiction to stop people from multiplying. But what I can tell you is you're 27 years old. You already have 2 children and you have 2 different mothers for 2 children. And obviously the mother in this case, you also have some sort of, relationship issues. I'm assuming the mother of your other child, you had some sort of relationship issues. That's why you're not together. And right now, Child Protective Services is taking care of your child. So now is the time for you to get your act together and be a father. If you're going to be a father, be a father, be the best father that that child could want. If you're not going to be a father, let that child know so that child won't hang their hopes and dreams on you being a father. You understand?
Yes, ma'am, I understand that.
All right. Are you employed?
No, ma'am, I got a job waiting for me, but right now I'm on house arrest, so no.
All right. So what are you going to be doing at this job?
I'm an HVAC technician.
Okay. All right. State, are you going to ask that he remain on GPS or no?
At this point, Your Honor, no, based on our conversations with the people involved.
All right. So it's going to place you on 5 years deferred adjudication, proof of employment within 30 days. There's to be no employment as a home health care provider or any employment of minors. CPS compliance, if applicable. They should be requiring you to do parenting classes, but just in case they don't, I'm going to want parenting classes with compadre e compadre. And of course, if you're doing parenting classes for Child Protective Services, that will be acceptable. 120 hours community service restitution. I'll deduct 40 of those hours if you provide proof that you've obtained your COVID vaccination. So the record is clear. I'm not forcing anyone to get the vaccine if you don't want to get it. But if you do get it, 40 hours will be deducted. And if you successfully complete all of the courses and the requirements that CPS is giving you, then I will have the rest of the community service hours waived. The BIPP course, again, Rebecca, anything that they're having him do on the CPS side, if it's the same thing that I'm asking, then that will be acceptable, the courses on CPS. So BIPP, anger management, intensive outpatient treatment with probation, I'm going to want regular UAs, but test for levels. Who are you living with right now?
My aunt.
Okay. We're going to do random field visits. 2 times per month. Taking consideration NIMAG number 617067, 617068, County Court cause number 651269, 2020 CR 5073, restitution for lab testing. Mr. Zamora, if you think that amount of restitution is too high, just let the court know and we'll have a hearing on that matter.
Okay.
There's to be regular reporting by Zoom or in person. So if something happens and you can't report by Zoom, you can report in person.
Okay.
There's to be no harmful or injurious contact with Leo Reyna and Victoria Lopez. There's a $1,000 fine that will be probated. Rebecca, is there anything else that Mr. Reyna needs?
No, ma'am.
Mr. Reyna, is there anything else that you need from the court in order to be successful?
No, Judge.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Reyna, here's the speech I give everybody. And I know people have heard it so much. Brenda's like, Judge, I've heard this speech so much. Let me just tell you, when you will know that you're ready for a relationship. Your first paycheck, or maybe your aunt will loan you the money, go out, buy an orchid. They're all in bloom right now, all beautiful at Walmart, at everywhere, at different stores. Get that orchid and keep that orchid for a year. And if that orchid remains alive and blooming, you're ready for a relationship. Because orchids require patience. You can't move them too much. And if you do move them, you have to be very tender with how you move them. If you are able to keep that orchid for a year, that means that you have patience and you may just be ready for a relationship. So my advice to you, no more relationships. You understand? Until you have an orchid that can bloom and be in bloom for a year.
Yes, Judge, I understand.
All right, I'm gonna send you to breakout room number 2.
Okay, thank you.
You're welcome. And probation will go there and go over conditions and you can be excused from that room.
Okay, thank you, Judge. Have a good day.
Oh, thank you. You have a great day too. Rochelle Acevedo?
Your Honor, may I be excused?
Yes.
Thank you. Have a good day.
Man, how do I
Okay.
go to the breakout room?
Oh, if you just look at the bottom of your screen on your phone, just tap it. Or do you have an iPhone or an Android?
An iPhone.
Ooh, well, that excuses me. Brenna, take it away.
I got it. Thank you.
All right, thanks. Brenna, I'm always praying, please let them say iPhone and not Android. All right, Rochelle Acevedo, who you have?
Dominic Hernandez. He's in custody, Judge.
Okay. And I think this was supposed to be for a plea, is that correct?
I need to discuss that with him.
Okay. Mr. Hernandez, I'm going to send you to breakout room number 3 with your attorney. All right, and then Gary Churek, you said that Mr. Williams wants a jury
trial,
trial.
Your Honor. Yes, ma'am.
All right, I'm going to send you to breakout room number 1. Could a prosecutor join Mr. Churek in breakout room number 1 to confer with Ms. Ferguson on a jury trial date, and then I'll need you all back into the main room.
Okay.
And then on Janelius Crew, what is happening with Mr. Crew?
Your Honor, I believe Mr. Nisbet was going to request a continuance.
Okay. For what are you all asking for?
Well, the issue is that there's evidence that hasn't been delivered to me. I'm not sure how much detail to go into, but I will have to see Mr. Nisbet this week for some of the evidence, and some of the evidence he doesn't even have yet, and he's waiting on receipt of that evidence before we can proceed.
All right, Mr. Crew, can you unmute for me?
Yes, can you hear me?
Yes, I can hear you. Mr. Crew, my understanding is that your attorney needs to obtain some more evidence. In this court, I'd like for the state and the defense to have the evidence that they need for us to go forward, okay?
Yes, ma'am.
So we're gonna get a reset, and is 30 days enough time for both the state and the defense?
Maybe, Judge. So the contents of the phone extraction, of his phone extraction from the Secret Service I have, and I have an appointment to give to Eduardo. However, the location of his phone and those reports from the FBI, I don't know, because the feds can move at a different pace. So I guess we could start with 30 days and then we can work from there.
All right, well, this is what the court will do. This is unusual, as the state knows. Mr. Jimenez, I'm going to send you to breakout room number 1. Ask Ms. Ferguson to give you a 45-day reset, and she'll come back in the room and tell me what day that is she wants to set it on, okay?
Yes, Your Honor.
And let me find you. All right, Mr. Crew, I'm going to get that date and we'll come back, okay? And Eduardo, you can go to breakout room number 1. And everyone, just give me a moment to let me get this date. Acevedo, you're in the courtroom?
Yes, Your Honor. I just have an order that I need a signature on for ignition interlock removal for a case that was dismissed.
All right, if you will give it to the clerks, they'll make sure I have it.
Thank you, Your Honor.
You're welcome. And everyone, just put some patience in your pocket and we will be right with you. Mr. Crew? Can you unmute, please?
Yes, ma'am.
Mr. Crew, we're going to bring you back on December 2nd, but if your attorney has everything before that date, come back and we can get you an earlier date, okay?
You say December 2nd?
Yes.
Okay.
All right, but if your attorney has all of the documents before then, we can come back before then. Your attorney will let us know, okay?
Okay, ma'am.
All right, thank you. They're gonna take you back now, Mr. Crew.
Okay.
Thank you.
All right. Thank you.
Bye. All right, anyone else need to go to a breakout room before we take up the matter on Mr. Hitchens' client?
Oh, Your Honor, Barry Hitchings, I don't know if James Salazar, the defendant, was brought over or not.
No, he's on the screen.
Oh, okay. I don't see him. If I could just have a very short conversation with him to let him know what's going on.
All right, I'm going to send you to breakout room number 5.
Thank you, Your Honor.
You're welcome. Let me just find you on the screen. 1 second. Gary Chirek, your client wants a jury trial. Mr.
That is
Williams?
correct, ma'am.
And do you have a date for me?
January 12th.
Who's the attorney on this case?
Hunter was online when we discussed the date.
All right, is there a prosecutor available to put this jury trial on the record, please?
Hunter Morris, Judge.
Ah, see, Hunter is back. We just have to call his name twice. Brenna, we're having problems with the spotlight. Let me see. Let me see. Oh, there we go. I don't know why it does that sometimes. Court is calling 2019 CR 12531 and 2020 CR 2536, State of Texas versus Dramatic Williams and Kenneth
Call him
Williams.
on the phone.
What is your client's
Well, I call Michelle,
correct
my
name?
sister Michelle, the one that she said I could live with her.
Ms. Williams, Mr. Williams, what is your correct name?
No,
Kenneth Williams.
I just talked to her.
All right,
I
so we
talked
have
to her
State of Texas
about
versus
life
Kenneth
and stuff,
Williams
you know?
and State of Texas versus Dramatic
Yeah.
Williams. May I have parties announced for the record for the state,
Hunter Morris.
for the defense?
Gary Chirek.
And are you Kenneth Williams?
Yes, ma'am.
Yeah, my mother.
And are you also listed under Dramatic Williams?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objections from the defense?
None, no objections, Your Honor.
Mr. Williams, do you have any objections with us proceeding by video?
No, ma'am.
Defense, in each of these cases, have you received all the discovery?
I have, Your Honor.
And the court will note for the record that in each of the cases, the court has acknowledgements of discovery dated October 1st, 2020. Has an offer been tendered in each of these cases, Mr. Chirek?
Yes,
I was
ma'am.
living with my mother in
Mr.
Haven for
Williams, are you rejecting the offer in each of these cases?
Yes, ma'am.
My understanding, both parties have had a
Yeah, I was
chance
back
to
and
confer
forth with
on a
my
jury
mother
trial
and
date.
Haven for
Mr.
Homestead.
Williams, your plea deadline date in this case has expired. My understanding,
Well, I was
both
only
parties
out for like
conferred
a
on a
month.
jury trial date. Your jury trial date will be January 12th, 2022
Yeah.
at 9 a.m. Any objections to that as a jury trial date, state?
None, Judge.
Defense?
No, Your Honor.
Mr. Williams, do you have any objections to January 12th as your jury trial date?
No, ma'am.
All right, Mr. Williams, your jury trial will take place January
Who's
12th,
good?
2022
Yeah,
at 9 a.m. in the 187th
Yeah.
District Court. The court is located at 300 De La Rosa on the 4th floor. If you are in custody, you will be brought over from the jail dressed for trial. However, if you are on bond, you will need to appear at 9 a.m. on January 12th, 2022. Do you understand?
Yes, ma'am.
When is your court date?
January the 12th,
What time?
I have
9
high blood
a.m.
pressure.
Which court?
Yeah.
187.
All right, if there's nothing else, we will
Yeah.
close the record.
Yeah.
Thank you, Your Honor. Be excused.
Yes, you may be excused. Norma, you can let them know that
Can I
14-0 can go back, please.
Yes, ma'am.
All right, anyone else ready before we start the hearing?
Judge, I'm ready on the hearing, but I also just let Norma know that we've reached an agreement on Gerald Mack. So I sent his email and what the offer is. And so she's going to, I guess, circulate the trial court cert and the waiver, and then Marcus is working on the paperwork.
Okay, and then anyone else ready? Eduardo Jimenez, do you have someone else with us?
Yes, Judge. I have several. Mr. Johnny Gonzalez is ready on a plea.
Okay.
Mr. Jace Meager, we had talked about resetting that one to contemplate a plea, but you told you were going to recall him to 2 o'clock. And then Isaiah Gonzalez is a motion to set bond.
Okay, Isaiah Gonzalez, this is the one with the GPS, correct?
Yes, so Your Honor, that's correct.
All right,
Your Honor. Sorry.
No, go ahead.
And we have his, well, she's no longer with pretrial services. She actually works for the federal government now, but we have his pretrial services officer from the time of the violation on Zoom.
Okay. All right, Mr. Isaiah Gonzalez, can you raise your hand for me, please? Okay. All right, court is calling 2019 CR 7912, State of Texas versus Isaiah Gonzalez. Can I have parties announced for the record for the state?
Michelle Hated for the state.
For the defense?
Eduardo Jimenez for the defense.
And are you Isaiah Gonzalez?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
All right, defense has filed a motion to set bond. State, are you ready to proceed on the motion to set bond?
Here, Your Honor.
All right, defense, is your motion. You may begin.
May I call Mr. Isaiah Gonzalez as a witness, Your Honor?
Mr. Gonzalez, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. And if you could state your name for the record, please.
Isaiah Gonzalez.
Mr. Gonzalez,
Defense?
I'm sorry.
No,
may I go?
defense, go ahead.
Thank you, Your Honor. Mr. Gonzalez, is it true that you've been incarcerated on this charge since October 2nd, 2020?
Yes, sir.
So it's been a little over a year, is that correct?
Yes, sir.
And what are you asking the court to do for you today?
I'm asking the court to set me a bond so that I may be able to. I've really been incarcerated 2 years, but since the last, since 2020, when I was out on bond, I picked up allegations which are not dismissed. And
what are you asking the court to do for you today?
I'm asking the court to set a bond for me so I mean, opportunity to bond.
Would you please describe the bond amount that you had originally?
100,000.
Okay. And would your family be in a position to help you bond out if your new bond was in that range, somewhere in that range?
We can make something happen. It'll take some time, but I will be able to make bond again. We've kind of already arranged something between
okay
my career and my family.
Why were you remanded without bond in the first place, Mr. Gonzalez?
Because I had picked up allegations and there was an incident at my house, which has now been taken care of. So I violated bond, and that was considered a violation of my bond to pick up those charges.
Did one of those violations have anything to do with the GPS monitor?
Yes, sir.
Were you accused, or was it alleged that you cut off that monitor or somehow tampered with it?
It was removed by the officers of that night.
I'm sorry, it was removed by the officers, did you say?
Yes, sir.
Why
I'm
did
sorry, now time out. Mr. Gonzalez, I need you to repeat your last answer.
The GPS was removed by the officers.
Why did the officers remove your GPS?
Well, I told them my situation, and they told me, well, where I was going, I wasn't going to need it.
What about the other violations?
It was a aggravated assault with a deadly weapon. It was a.
All right, time out, just one moment. Mr. Gonzalez, can you do me a favor? Can you put the microphone inside your mask or either speak more clearly, because we're having a difficult time hearing you?
Yes, ma'am.
That's better.
Okay.
Yes, what were the other violations?
It was a aggravated assault with a deadly weapon. Dismissed.
And you said there was something at the house that was resolved. What are you referring to, sir?
The incident. Well, there was an altercation, and the police were called. I was arrested for that. 7 months later, it was dismissed.
Okay. Why can you give the court a reason why it should reinstate your bond despite the fact that you had violations?
Well, to be honest with you, I just don't want to be locked up anymore. I'd rather fight this case on the outside. If I have to stay at my house on house arrest, GPS monitor, like I was before, I can. You know, I spent 2 years in here, and I'd rather spend it out there at my house, and so that we can continue with this process while I'm out there in the free, rather than incarcerated.
Pass the witness, Your Honor.
Good afternoon,
Right,
Mr.
stay.
Gonzalez. So your bond was previously set at 100,000. Is that correct?
Yes, ma'am.
But you violated that bond by cutting off your monitor. Is that correct?
It was yes.
And are you familiar with Lauren Garza? She was your pre-trial.
Yeah, she was my pretrial services officer. I kept in contact with.
And do you remember refusing to be reinstalled with your GPS device after it was removed?
No, ma'am.
You don't remember that?
No,
ma'am. Mr. Gonzalez, you have 2 prior convictions for unlawfully carrying a weapon. Is that correct?
I believe it's 1.
You're saying it's just 1?
One was a misdemeanor, and one was a unlawful carry.
So there was a misdemeanor, unlawful carrying, and was there also a felony that was reduced to a misdemeanor?
I don't remember, ma'am. I was young.
Do you remember having an unlawful carrying of weapon in the 175th District Court that you were sentenced to 6 months in jail on?
Yes, ma'am.
Okay. And then do you remember having an unlawful carrying of a weapon in County Court 4 that you were sentenced to 45 days in jail on?
It was yes, ma'am.
Okay. So you've had 2 prior weapons convictions.
Yeah, I was dumb. I was doing things. I was young. I was doing dumb things. I lived alone. I lived in the streets. You know, but I took good care of myself now. You know what I'm saying? But that was before. It has nothing to do with my situation right now.
And in this case, you're accused of shooting your brother, Christian Martinez. Is that correct?
Which is not true.
You're not accused of that?
I am accused of that, but it's has nothing to do with my situation.
Where was he shot?
I have no idea because I haven't been caught up with any of the updates, any of the details on this case.
Do you remember admitting to shooting him?
I did not.
You don't remember that? So you don't remember telling officers that you were mad at him when you shot him?
No, that didn't happen.
When you were arrested for the aggravated assault in October 2020, after you were already on bond for this case, what happened in that incident?
There was someone who I considered a friend. I guess he was going through something. He was on drugs, and he got into an argument with me on the phone. And since I'm not allowed to leave the house, he came to my house, and I told him not to do that. And he came, and he was, I don't know, he was on drugs, and he pulled out a knife on me. And it ended up becoming an altercation in my front yard.
An altercation where he was stabbed, right?
Where, yes, he tried to stab me, and it turned around into a self-defense situation.
So you've obviously had a problem previously complying with your bond conditions. Is that correct?
No, that's not correct.
Were you working before you committed or before you were charged with the aggravated assault against your brother?
I was working before I was arrested.
Where were you working at?
I was working at Real Cantina at Riverwalk.
But you haven't worked for the last 2 years, right?
I've been incarcerated.
And at the time, though, after you were arrested for this offense, were you still working?
When I asked that again?
After you were arrested for the aggravated assault against your brother, the case that is still pending, were you still working after that?
No, ma'am.
No? Okay. So you weren't working at all while the case was pending?
No, ma'am.
I'll pass the witness.
Defense?
No further questions, Your Honor.
All right, defense, any other witnesses or evidence?
No, Your Honor.
All right, state, any witnesses or evidence?
Yes, Your Honor. I just emailed you a copy of the EMS records, which were previously filed with the court and provided to defense with the business records affidavit, just discussing the injuries that were sustained by our victim in this case, Christian Martinez, who was shot in the chest by the defendant.
Are you offering that, Ms. Hayden?
Yes, I'm offering that as State Exhibit 1.
Any objections?
No objections, Your Honor.
All right, State's Exhibit number 1 is admitted. And for the record, the court will receive emails of exhibits through the state, but the court does not view those emails until they're actually admitted into evidence. And it is sent to the court because we're all doing this by Zoom, and it will be forwarded to the court reporter. So State's Exhibit number 1 is admitted into evidence. State, any witnesses or other evidence?
Yes, Your Honor. The state calls Lauren Garza.
All right, Ms. Garza, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, and if you could state your name for the record, please.
My name is Lauren Garza.
All right, state.
Good afternoon, Ms. Garza.
Hi, good afternoon.
Are you familiar with Isaiah Gonzalez?
Yes, I am.
How are you familiar with him?
I was his GPS supervision officer when he was out on bond.
And do you see him anywhere on Zoom?
Yes, I do.
Okay, could you please identify him by some identifying mechanism on Zoom?
Yes, he is wearing an orange top with a mask covering half of his face with some black headphones.
Objection, Your Honor. Everyone there is wearing orange with masks. Well, you can't see them all, but everyone there is going to have a mask and an orange jumpsuit.
Can you lower his mask?
For what?
So that I can identify you.
Mr. Gonzalez. Yes.
Okay, the defendant has a cross under his left eye.
Are you still with? Sorry.
State.
Your Honor, may the record reflect that she's identified the defendant Isaiah Gonzalez?
All right. You may continue with your questions. State.
All right, Ms. Garza, are you still with pretrial services?
I am not. I am now employed with the U.S. Pretrial Services here at the federal courts in Del Rio, Texas.
And when did you leave Bexar County?
My last day with Bexar County was on August 13th.
How long did you work with Bexar County as a pretrial supervision officer?
For about 2.5 years.
And what were your duties with regard to Isaiah Gonzalez?
I was just his supervision officer, specifically because he was on a GPS monitor. So just making sure that he was reporting every month like he was supposed to, and just ensuring that he was following the conditions of bond that he was released with.
And what offense were you supervising him for?
The offense was the, I don't have a case number, but I know it was for the aggravated assault. I believe with the aggravated assault with a deadly weapon. Actually, I do have the case number, sorry. Yes, the felony 1 aggravated assault with a deadly weapon.
And did he have any violations while you were supervising him?
He did not have any official violations. I did get after him a couple of times. However, the only major thing that happened was the strap tamper, which was a warrant. It wasn't I guess a violation against his conditions of bond, yes. But it was a warrant and an update letter that was submitted to the courts.
Okay. So can you tell me what happened with the GPS strap tamper?
Yeah, so we basically got a phone call from, well, the on-call officer got a phone call stating that she got an alert that generated for him, which was the strap tamper. And basically he stated that I wasn't allowing him to do simple things, for example, to get grocery shopping or to get hygiene items. And that was the reason why he cut off his GPS monitor, was because he just couldn't take being on house arrest anymore. So I didn't contact him until about a couple of minutes after he had spoken with our on-call officer. But I did talk to him that night that the strap tamper was generated. And he did say that he was not going to go get a new one on, a new GPS monitor put on.
Okay, so he refused to comply with the conditions of his bond.
Right.
When someone tampers with their GPS or cuts it off, is there anything that you guys can do to ensure that that won't happen again?
No, because when they're at home, I mean, if they're going to cut it off again, they're going to cut it off again. We do give them the chance to get another GPS monitor put on them. And that's something that we explain to them and the technician, whoever's on call, that they do have an opportunity to get back into compliance. But if there's been circumstances where people get a new one put on and then they just cut it right off. So again,
And when they tamper with their GPS device, do you guys receive a notification right away? How does that work? How long does it take to get notified?
it notifies us right away.
And are you aware that the same day that on October 1st, 2020, when the defendant tampered with his GPS monitor, he was also arrested for another offense?
Yes. So when we had to retrieve the GPS monitor from the SAPD property room, and there was a note in his bag, or there was a sticker on the bag stating that the defendant had cut the GPS monitor off prior to fleeing from SAPD. And then we picked up the monitor there at the SAPD property room. The officers picked it up for us.
And just one moment before you continue. If Ms. Pratt, if you can go to number 2, and Jason DeLeon, if you'll go to breakout room number 2 to fill out paperwork, please. All right, you may continue, State.
I'll pass the witness at this time.
No
All right,
question.
defense, any questions?
No questions for this witness, Your Honor.
All right, State, any other witnesses?
No other witnesses.
Any witnesses subject to recall?
Not from the defense side, Your Honor.
Not from
All right.
the state.
All right, so Ms. Garza can be excused.
Thank
Yes,
you,
Your
Your
Honor.
Honor.
Yes, Your Honor.
All right, thank you, Ms. Garza. All right, this time the court will hear argument. Defense is your motion. You may proceed.
Your Honor, this individual, Mr. Gonzalez, this young man has been incarcerated for quite a long time. It's been over a year. It's his own arguments, of course, that he testified to was that, after being such a long time in jail, he would obviously accept any of the court's orders to be on full house arrest. He just wants to be with his family, wants to be at home, and also perhaps have the advantage of dealing with his charges on the outside rather than the inconvenience of having to deal with them on the inside. He did prevaricate a little bit when I asked him about the GPS device, but he answered truthfully when questioned by the assistant district attorney about what happened with that GPS device. There's no excuse for it. So we're not trying to offer an excuse, but to get to the point, he was employed. He was doing well until he got arrested, and he was doing well according to the pretrial officer. He was doing well and didn't have any major violations except for the single violation that they mentioned about the tampering with the strap. So we can make this a hearing about tampering with the strap, or we can consider whether he might be safer and in a better place with his family. We would request the court to kindly set a bond for Mr. Gonzalez, and we have had prior discussions with the state about, we have an agreement with the state about what the bond might look like and what the conditions might be. Of course, all of that is subject to approval and in modification or complete rejection by the court.
All right, and counsel, when you mentioned for the defendant to be with his family, the state's exhibit that I read, it's alleged that he shot his brother. So that's not a part of the family that you're intending for him to be with.
No, of course not, Your Honor.
Okay, no, I wanted to understand. All right, state.
Your Honor, given the nature of this offense, future safety of the victim, defendant's prior criminal record with 2 weapons convictions, the fact that he's previously not complied with bond conditions, And the fact that $100,000 was not enough to assure that he complied with those conditions, we do have some major concerns about the defendant making bond in this case. We had discussed an amount with defense earlier of possibly $150,000. In speaking with pretrial services and our witnesses, we would ask that that would be the minimum the court would consider if the court is inclined to grant him bond. And we would ask the court to consider that possibly the court should not grant him bond in this case. But if the court were to, we'd ask for full GPS tracking with house arrest, which defense has already previously had an issue with. We'd ask for a no contact order with Jose Mercado, Christian Martinez, Kayla Gonzalez, and the victim on the aggravated assault case that was dismissed subsequently, Alfred Gonzalez, random UAs, no firearms. I'm not sure if there's anything else the court could do to ensure that the defendant will comply, given all the concerns in this case.
All right, so state, are you asking for the defendant not to have a bond? Or are you asking that his bond be set at $150,000? Because the only thing the court has before it now is a motion to set a bond, not to deny a bond.
We're just asking that it be set high enough to give a greater assurance that it will be complied with. And include all of those conditions. Obviously, the $100,000 which he made wasn't high enough to ensure that it would be complied with.
So state, are you asking for $150,000 bond?
We would ask for that, and whatever conditions that you can put on him to ensure that his family, his brother, and other members of the community will be safe.
And defense, what are you requesting in the amount of bond?
We have an agreement as to the amount, Your Honor, we also have an agreement as to the no contact, and in fact, all the elements that the state mentioned, we had an agreement to all of those elements. The only thing we did not agree on was that $150,000 would be the minimum. We had an agreement that would be, in fact, that would be our agreement, that it would be $150,000, and that would be our recommendation to the court.
So you all are in agreement then to a bond amount and conditions of bond? Is that
Correct.
what the court is hearing?
Correct, Your Honor.
That's what we discussed earlier, Your Honor. As I mentioned, we didn't have our witnesses this morning.
All right, so if both parties want to send me here's the situation, Mr. Gonzalez. Can you unmute for me, please?
Yes, ma'am.
Mr. Gonzalez, you cut off your monitor.
That's what I was told to do, ma'am.
Wait a minute. Is he saying somebody told him to cut off his monitor?
The officers of that night told me to remove it because I wasn't going to need it where I was going.
No, are you telling the court that an officer, and let's stop using the term remove, because the only way you can remove a GPS monitor is you have to cut it off. So are you telling the court that an officer, and Eduardo Jimenez, I'm just going to put the question out there, and I'll allow you to discuss with your client before he answers. It appears that your client is telling the court that an officer told him to remove, which means cut off, his monitor. So he's saying either that's a pretrial officer or either some of the officer of the law told him to cut off his monitor. And before you delve into that, I'll give you a chance to speak to your client. And if the state wants to recall any witnesses and we need to reopen this hearing, we can. But if your client is saying someone told him to cut off the monitor, then that's a different thing altogether. But he's saying, it appears, that someone told him to cut off his monitor. And he's saying it was an officer. And from the testimony that I've heard from pretrial services, it doesn't appear that the pretrial services officer who came to testify doesn't appear as though she was the one who told him to cut off the monitor, if anyone did tell him to do that. Which I'll let you talk to your client.
In a breakout room or right now in front of?
Oh, no, I'll let you talk to him in a breakout room, because if you, and we'll take this up after you speak with him.
Yes, ma'am.
I'll send you to number 4. Who's the prosecutor on Stephen Gilmore and Salazar?
The one with Barry Hitchings, Judge, that's Hunter. And then the case I have that's ready to plea is Gerald Mack, and that's with Marcus.
Okay, on Gerald Mack, the court has just received the documents. And what I will do then is I'll send Mr. Mack to breakout room number 1 to be sworn in by the clerks. And I'll send you to one as well, Mr. Gilmore.
Okay.
Just to make sure that all of the documents are there.
Sure.
And I'm trying, there you are.
Got it.
Okay. Can everyone just give me a moment, please? Jeremy Alvarez, if you've already talked to your attorney, then you are excused.
I haven't talked to him yet.
All right, just one moment.
Okay. I haven't talked to my attorney yet. You said you did for a moment.
We're ready, Your Honor.
All right. Your client is not back in the main room.
Let me go back in and tell him to.
All right, thank you. There you are. All right, thank you, Mr. Jimenez. So is your client still saying that someone told him to cut it off?
Your Honor, he's admitting that he cut it off on his own volition.
Okay. All right, and you in the state have an agreement?
Yes, Your Honor, we do.
All right, then state if you'll put your agreement on the record, please.
Judge, based on the fact that this morning when the motion is set bond, we did not have our witnesses available, we agreed to 150,000, half of what the previous bond was, or 50,000 more than what the previous bond was at 100,000, in the hopes that that'll be high enough to assure compliance. We'd also ask for full GPS house arrest, no alcohol, urinalysis, no contact with Jose Mercado, no contact with Christian Martinez, no contact with Kayla Gonzalez, no contact with Alfred Gonzalez, no firearms. Those were all terms that were discussed with defense. And if there are any other terms that the court can add on to ensure compliance with defendant's bond, we would ask for that as well.
All right, and you say Alfredo Gonzalez, and who is the other Gonzalez?
Alfred Gonzalez, Kayla Gonzalez, Christian Martinez, and Jose Mercado.
All right, this is what the court will do then. The court will set the bond at $150,000. There's to be full GPS. No contact with Jose Mercado, Christian Martinez, Alfred Gonzalez, Kayla Gonzalez. No firearm possession. And pretrial services to perform field visits 3 times per month random. Is there anything else?
And Judge, does that include the full GPS house arrest?
Yes.
Does that include any UAs?
No. He should, I don't want him leaving the house at all, even to go do a UA.
Well, there's nothing further from the defense, Your Honor.
Okay. And do you have all of the discovery in this case?
Yes, I do, Your Honor.
Norma, what is the next court date for Isaiah Gonzalez, please?
1 second, Judge.
Thank you.
He's waiting trial for January the 12th, Judge.
Okay. All right. Mr. Gonzalez, your jury trial date is going to be January 12th, 2021 at 9 a.m. in the 187th District Court. If you are still in custody, you will be brought over dressed for trial If you're not in custody, you will need to appear in the 187th District Court at 9 a.m. on January 12th, 2021. Do you understand?
Yes, Your Honor.
All right, then, that will be all. Norma, can you let them know L14 can go back, Gonzalez?
Yes, ma'am. I send you a chat.
All right, thank you. Thank you. 2022, Mr. Gonzalez. That is January 12th, 2022. Thank you. Brenda, time is moving too fast. Who would have thought we would be saying 2022?
I know, it's crazy.
Yeah. All right, then, Mr. Jimenez, the next person you have is Meager.
Yes, and the issue there was that he was offered for the first time a plea bargain, and I'm asking for some time to review both discovery and the plea bargain with him. And you know from previous conversations, Judge, that I'll be out from the 9th to the 15th of this month. So I plan on seeing him once before I leave and then right when I get back. So once before the 9th and once right after the 15th.
All right, Norma.
Yes, ma'am.
You put this for the last week in October. Is that enough time for you, Mr. Jimenez?
Yes, Your Honor, yes.
I don't understand what the point of that was. Like,
excuse me. Yes, okay. Can you,
the
give me a date?
29th?
All right, October 29th. All right, we'll see you back on Mr. Meager at 9 a.m.
Okay, there's also, then Johnny Gonzalez was the last client I had, and that was a plea bargain, Your Honor.
All right, thank you. As soon as the court has that, we will go forward.
Yes, ma'am.
All right, and then the parties on MAC.
Ready, Judge?
Sure. Everyone, just give me one moment, please.
Eduardo, your client hasn't signed the paperwork, Gonzalez.
So like this guy I'm about to plea, his name is
Hello?
Bye-bye. All right, Mr. Gilmore, you have Mr. Mack.
yes, Judge, ready to proceed.
All right, the court is calling 2021 CR 9094W, State of Texas versus Gerald Mack. We're gonna have parties announced for the record for the state,
Anders,
for the defense.
Stephen Gilmore for defendant.
And are you Mr. Mack?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
none.
Any objections from the defense?
None.
Mr. Mack, I'm going to show you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mack, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Court will show you what's entitled waiver of indictment, reading of information and rights under Article 1.05 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial?
Yes, ma'am. I understand.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm going to show you what's entitled information. Did you review that document with your attorney? Did you understand it?
Yes, ma'am. I did.
State, are you proceeding on the indictment? I'm sorry, defense, do you waive the reading of the information?
Waive the reading, Judge.
State, are you proceeding on the information as presented?
Yes, Judge.
Mr. Mack, I'm going to show you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am. I understand.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense?
He is and was.
Mr. Mack, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review this page and did you understand?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's a $1,000 fine. There is no application for deferred adjudication. State recommends community supervision. There's $60 to DPS for blood alcohol testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Judge. There was one other term, which was the 10 days Bear County Jail, and I was just going to make a request on the 10 days.
Okay, that's outside your agreement.
Right.
Okay. All right. State, is that the agreement?
Yes, Judge.
Next, I'm going to show you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No motions, Judge.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 100 hours of community service restitution, 10 days in the Bexar County Jail as condition, DWI intervention, victim impact panel live, ignition interlock for half the term of supervision, and 2-year Texas driver's license suspension. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charging the information, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
Yes, Judge. The state offers states Exhibit 1 and its attachments.
No objections, Judge.
All right. Mr. Mack, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and judgments, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am. I do.
Court will find that defendant has knowingly and voluntarily waived and consented to testimony of stipulations and stipulations. And the court will accept into evidence states Exhibits 1 and attachments and review the same. All right, after reviewing states Exhibits 1 and attachments, court will find that the court will find there's sufficient evidence to find the defendant guilty, and the court will find the defendant guilty. Are you proceeding with sentencing?
Yes, waive PSI, Judge.
Anything you wish to say on behalf of your client?
Judge, but for the violation reports, he seems to have adjusted well on pretrial supervision. He's gotten back and employed. He did have 2 high blows, but he has been on pretrial supervision since May. He's informed me that he has cut out drinking and is taking additional affirmative steps in his life to maintain his sobriety. I believe he will be successful on probation. We do have, as part of our recommendation, is the 10 days Bexar County Jail, which is of course a statutory requirement. I would just ask that if the court does impose those 10 days, which I expect it will, that the court allow him to complete those 10 days either on work release or through the participation in the Bear Gives Back program, if that's something this court permits.
All right, state, do you have any recommendations, Mr. Gilmore? Usually what the court does in lieu of the 10 days in the Bexar County Jail, the court usually does GPS, but I do understand that GPS is expensive. State, do you have any objections to the defendant serving the 10 days during the Bear Gives Back program?
No, Judge.
Mr. Mack, what do you do for a living?
I work for a moving company.
Okay. And if you're drug tested today, what are the results going to be?
Clean.
Of everything, including marijuana?
Yes, ma'am.
All right, this is what the court is going to do. Sentence you to 4 years in prison, suspended and probated for 4 years, $1,000 fine, probated, $60 restitution to DPS for drug testing, ignition interlock for half the term of probation. Bear gives back in lieu of the 10 days Bear County Jail. 100 hours of community service restitution, 40 of those hours will be waived if you obtain the COVID vaccine. Whether you get the vaccine or not, it's completely up to you. If you obtain the vaccine, then the court will deduct 40 hours upon proof of that. DWI intervention, victim impact panel live, 2-year Texas driver's license suspension, random field visits 1 time per month, regular UAs, regular reporting by Zoom or in person. So if something happens and you can't report by Zoom, then you'll need to do it in person. Proof of employment within 15 days. No employment as a home health care provider or with minors. Rebecca, is there anything else that Mr. Mack needs?
No, ma'am.
Mr. Mack, is there anything else that you need from the court in order to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, you can go off the record. Mr. Mack, I read the report and I read everything that you told the police at the time of this incident. And you know, and I know, because of whatever medical issues you have, you should not be drinking at all. Do you understand?
Yes, ma'am.
All right, I'm going to send you to a breakout room. Probation will go over conditions with you. I'm going to send you to breakout room number 4. And after that, you are excused.
Okay. Thank you, Judge.
You're welcome.
Best of luck to you, Gerald.
Judge, can I see you in a breakout room before I go over there?
Sure, you want to go to breakout room number 1?
Yes, please.
All right, everyone, just give me a moment. Jeremy Alvarez. I'm going to put your attorney's office number in the chat box so that you'll have the information to contact him.
Yes, ma'am.
All right, do you see the number? Just 1 second. That's the, well, it's not, just 1 second, it's not taking it.
I got the number.
All right, this is the last number in the box. That's his number. All right. And Mr. Meager, you've already been given a set time to come back, so we're going to excuse you, okay?
Okay, thank you.
All right, you're welcome. Did your attorney tell you when you would come back?
No, not that I remember.
All right, Norma, what's the date for Mr. Meager?
1 second, Judge. The 29th of October.
All right, we're going to bring you back on October 29th, okay?
Yes, ma'am.
Thank
There you
you.
go. Yeah, have a good day.
All right, you too. Number 1112 can go back.
Cause time was phone.
All right, Mr. Alvarez, do you have your attorney's number?
You lost it, right?
All right, it's 222-8284.
8284.
Yes.
We got it. We got it.
All right, thank you.
Thank you.
Rochelle Acevedo.
I'm
Hi.
sorry. Hi, Judge. So my client is going to take a plea. I was just chatting with Michelle. She's going to do the paperwork.
All right, thank you. And then are we ready on Salazar, Mr. Hitchens?
Yes, we are, Your Honor.
And Judge, for this hearing, I do have a few exhibits. So if I could get a good email address from Mr. Hitchens, I will send that.
All right, Mr. Hitchens, can you put your email address in the chat box?
Okay, I will try to do that.
All right, thank you. And Eduardo Jimenez, Mr. Meager will be back on October 29th. And then you have Johnny Gonzalez. What is happening with Johnny Gonzalez?
I believe he's ready to go, Your Honor. I don't know if your courtroom, if you have them swear him in, but he would need to be sworn in that case, and then we'd be ready to go.
All right, I'm going to send him to breakout room number 1.
Okay.
And Ms. Cantu, if I can see you in breakout room number 5, please. And everyone, even though I'm in a breakout room, I'm able to see what is happening in this room. So if you need anything, just let me know. And I will be right back.
Oh, Steve, did you get the email from me on my email address?
I didn't get anything.
Oh, okay. It just, I hit Chad and up came to Stephen Gilmore.
Nope.
So, okay.
Yes, Stephen, I'll send you one too. I was going to ask for your email also.
Okay. Hunter, did you get my email address?
I do not see your email address.
Oh, okay. Well, that went to Steve. Okay. Well, let me go down to the chat again. Okay, come on. Tell you what, Hunter, why don't I just give it to you verbally?
Stephen, did you get it in your chat?
Wow, it's just to Stephen Gilmore. Okay.
You're on live YouTube, so unless you just want to broadcast your email.
It doesn't make any difference to me. It's BP in my last name, Hitchings22@gmail.com.
Okay, thank you. Okay, I sent you all the email.
I got it. Used to, the deal was under the old way it was done is if you put her in custody, then she was stuck there until she got to testify.
It's Monday on a Wednesday, but we're putting smiles on, so it's all good.
I put some extra pockets on, Judge.
Oh, and you know what? I don't have any pockets, but that's okay. I appreciate everyone's patience. All right, and let me send Mr. Luna to number 1, Pratt to number 1. And Rochelle, do you have the paperwork on Mr. Hernandez?
I'm almost done with that, Judge.
Okay, thank you. All right, everyone, just one moment. Okay, Johnny Gonzalez.
Yes, ma'am.
All right. Who's the prosecutor on Mr. Gonzalez? Who's the defense attorney on Gonzalez?
Eduardo Jimenez, Your Honor.
All right, the court is calling 2021 CR 4144, State of Texas versus Johnny Gonzalez. Can I have parties announced for the record for the state? Who's the prosecutor on Johnny Gonzalez?
Marcus Sanders.
All right, for the defense?
Eduardo Jimenez.
All right, are you Mr. Gonzalez?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Mr. Gonzalez, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you
Yes, ma'am.
electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you do that discovery with your client?
I received it all and I went over it with my client, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I waive it, Your Honor.
Stated it appears that you only proceeding on count one. Is that correct?
Yes, Judge, but we also have an oral motion to amend the indictment.
Yes.
In both count one and count two, it's alleged that the controlled substance is cocaine. We would ask to amend that to methamphetamine.
Any objections?
No objection, Your Honor.
Mr. Gonzalez, do you understand that that amendment is a substantive change to the indictment?
Yes, ma'am.
And do you still wish to proceed? And do you still wish to proceed with that change?
Yes, ma'am.
You have no objections to that change?
No, ma'am.
All right. And state you're also waiving count two in the repeat offender enhancement allegation?
Yes, Judge, that's correct.
Any objections?
No objection, Your Honor.
Mr. Gonzalez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count 1 with the amendment, you're charged with possession with intent to deliver a controlled substance? Penalty group 1 gram to 4 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he is, Your Honor.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is proceeding on count 1. They're asking that your punishment be assessed at 2 years in the prison. There are no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, it is.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
No, Your Honor.
Then to the offense is charged in count 1. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
Yes, the state offers State's Exhibit 1 and its attachments.
Any objections?
No objections, Your Honor.
Mr. Gonzalez, I'm going to show you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
To understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right, then the court will follow your agreement, sentence you to 2 years in the prison, give you credit for any time served. I've read in the documents that the defendant has a parole hold or parole violation. Would you request that this run concurrent with that, or has that matter already been resolved?
We're requesting run concurrent, Your Honor.
All right, does anyone have the cause number for the parole violation? Or which case that is?
I don't have it, Your Honor.
1 second, Judge.
All right, thank you.
And Eduardo, is he on parole for the attempted ag robbery?
Yeah.
Yes, that's what it says in the police report.
Okay, Judge, it's 1987, CR 3546.
All right, this will run concurrent with 1987 CR 3546. Mr. Gonzalez, the court does not have any jurisdiction over the parole to force them to run this concurrently. If your parole has already been revoked, then it will run concurrently. If not, it will be up to the parole board. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Gonzalez, how old are you?
I'm 54, being 55 in December.
All right, so here's the thing. You're getting to the point where more of your life is behind you than in front of you. Don't be the person who's at the prison or at the jail when a new person comes in and they want to know how things run and they say, ask Grandpa Gonzalez. Do you understand?
Yes,
you got to
ma'am.
start changing your ways. All right.
Yes, ma'am.
All right. Good luck to you, Mr. Gonzalez. Thank you. For the minutes.
Thank you, and God bless you.
Oh, thank you so much. God bless you too.
Judge, Mr. Gonzalez asked to speak to me after the hearing. Can
Okay.
we do that real briefly?
Yes, but make sure that you bring him back to the main room.
Okay, bring him back to the main room. Got it.
Yeah.
Okay.
So if you'll go to number 5, and Mr. Gonzalez, I'm going to send you to number 5.
Thank you.
All right. If there are no other pleas that are ready, we're going to take up this hearing.
I think my plea was ready, Your Honor, and that's Jason DeLeon.
Okay. Stephen Gilmore, you're like, I didn't buy into this.
I'll sign up for whatever you need, Judge. I'm your Huckleberry.
Oh my gosh. Okay. Nobody knows that that's from Tombstone but us. All right. Let me see. Jason DeLeon, he's still in breakout room number 1. Miss Pratt, can you go back to number 1 and have him come out of that room, please?
Yes, Judge.
All right. Then after we finish with this, we'll take that up. Mr. Gonzalez, can you go
Yes,
to
ma'am.
breakout room number 5, please?
I don't know how to do that.
All right. Do you see at the bottom of your screen where it says breakout rooms?
No, I don't
All
say.
right. What do you see at the bottom of your screen? Do you see chat or participants or breakout room at the very bottom? All right. Just give me a moment. We're going to get someone to help you. Ms. Ferguson, can you have a deputy come and help Mr. Gonzalez go to breakout room number 5, please?
Yes, ma'am.
Thank you. All right. Who's the prosecutor on DeLeon?
Hunter Morris, Judge.
Okay. To the clerks, do you have all the paperwork on DeLeon?
Judge, I don't think he pressed sign on one of the last documents because it didn't come through. So I'm trying to get him back in the break room really quick.
Okay.
Unless he can just press sign on his end.
All right. I'm sending him to breakout room number 1. Ms. Pratt, can you go to number 1, please, and make sure he does that?
Yes, Judge.
Thank you. Mr. DeLeon, you need to go to breakout room number 1.
Okay, I'm back.
All right, thank you, Mr. Gonzalez. Have a great rest of your day.
Thank you, ma'am. God bless you. Have the same day.
Oh, thank you. You too. Okay, are we ready now, Mr. DeLeon? Okay, let's see if this is gonna happen. Okay. All right. Court is calling 2021 CR 9093W, State of Texas versus Jason DeLeon. Can I have parties announced for the record, please, for the state?
Hunter Morris.
For the defense?
Clarissa Pratt for Jason DeLeon.
And are you Jason DeLeon? You're on mute.
Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objection from the state?
None, Judge.
Any objection from the defense?
No, Your Honor.
Mr. DeLeon, I'm going to show you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's in defense, what's entitled discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. DeLeon, I'm showing you what's entitled application for community supervision. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled waiver of indictment, reading of information and rights under 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, Your Honor.
Do you understand you have a right to have a grand jury determine whether or not to indict your case and hold you over for trial? Did you understand?
Yes.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm going to show you what's entitled information. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
I do.
State, are you proceeding on the information as presented?
Yes, Judge.
Next, Mr. DeLeon, I'm going to show you what's entitled court set punishments, defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
You're charged by information with driving while intoxicated third or more. That's a third-degree felony. Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, yes.
Mr. DeLeon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine probated. State will take in consideration County Court Cause number 669303. State recommends community supervision. There's no application for deferred adjudication. There's to be restitution of $60 to SAPD for laboratory testing. There's to be no harmful or injurious contact with Delma, D as in Don, ELMA, Corona. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor, sorry.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 120 hours of community service restitution, ignition interlock, or PAM device with affidavit of non-driving. And that is for 2 years. DWI intervention, DWI victim impact panel live, 2 years driver's license suspension, 10 days in the Bexar County Jail, and a referral to felony drug court. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the office is charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's plea?
The state offers states wanted attachments to include attachments sent via email.
Any objections?
No, Your Honor.
Mr. DeLeon, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to a jury trial, the right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, sir. My client is very remorseful for what he did. He understands that if he continues on this path, that it's going to lead to some extremely serious consequences, and maybe even death. So we understand that he has to take probation very seriously, and especially a probation under your court and under your supervision. So we ask that that you follow the recommendation by the state, and that Mr. De Leon be given a chance and an opportunity to right his wrongs.
All right, Mr. De Leon, are you employed?
I'm working with my father right now.
All right, do you have any children?
Yes, ma'am. I have an 11-year-old.
All right, and do you live with your child?
Not at the time. I've been away for a couple of weeks.
No, I mean in normal day-to-day
Yes,
life.
yes,
Does
ma'am,
your
I
child
do.
live with you?
Yes, ma'am.
All right, and
She
what do you
does.
mean you've been away for a couple of weeks?
Well, with the restraining order that I had on me, I couldn't see my son.
So is the restraining order still in place?
No, I believe it's off already due to this court process with
No,
Delma.
that wouldn't.
No?
No, you still have the protective order until November.
Oh, okay.
All right, so.
Terroristic threat, Judge.
All right, thank you. All right, this is what the court is going to do. Sentence you to 4 years in prison, suspended and probated for 4 years, $1,500 fine, probated. Taking consideration county court cause number 669303, restitution of $60 to the San Antonio Police Department. This no harmful or injurious contact with Delma Corona. Is she aware that this court is putting in a no harmful or injurious contact as opposed to a no contact?
Judge, if I may. Yes, I did speak with the complainant in the terroristic threat case, Judge, which is why I included the no harmful or injurious. She does understand that I'm including it. I'll defer to this court whether or not you would like to lift the emergency protective order, since that case will be dismissed, taken into consideration for this one. I would also note for the court that there was a victim impact statement submitted in that case. I was not able to find it, but in speaking with the complainant, she is aware that this plea is taking place and did not have a problem with it.
All right, thank you. So there's been no harmful or injurious contact with Delma Corona. 120 hours of community service restitution, 40 of those hours will be waived if you provide proof that you've had the COVID vaccination. Court is not requiring or demanding that anyone take the COVID vaccination, but if you do, 40 hours will be deducted. The ignition interlock or PAM device, if you provide an affidavit of non-driving, there's to be a 2-year driver's license suspension, and you're to be on ignition interlock or PAM for at least 2 years. Driving while, DWI intervention, DWI victim impact live. There's going to be a referral to felony drug court. If you're not accepted into felony drug court, then it'll be intensive outpatient treatment with probation. In lieu of 10 days in the Bexar County Jail, I will give you the Bear Gives Back program, and he's to do that for 3 Saturdays. And the only reason why I'm doing that as opposed to the 10 days Bexar County Jail is because of the pandemic. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. There's to be regular Zoom reporting. If something happens and you can't report by Zoom, you need to do it in person. Regular UAs. And I'm going to want random field visits 2 times per month. Rebecca, is there anything else that Mr. De Leon needs?
No, ma'am.
Mr. De Leon, is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, Mr. De Leon, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. DeLeon, I see in the police report where you drank a 12-pack of 16-ounce beers. That's an issue. You're going to ruin your liver. I always tell people, whenever there's somebody who's driving while they're intoxicated, if they get in an accident, you know who ends up dying or getting seriously injured? Not the driver, not the intoxicated driver, but it's always some family that's just minding their own business, having a nice Sunday drive, or either it's the intoxicated person's passenger. So don't drink and drive. You understand?
Yes, ma'am. Very clearly.
All right, I'm going to send you to breakout room number 1. I'm sorry, so to pop up, I'll send you number 2 so that probation can go over conditions with you. Ms. Pratt, you can go into breakout room number 2 or you can be excused. All right. And Ms. Cantu, I'll send you in number 2 so you can see what probation officers do. One of the many things. All right, and then we're going to take up Barry Hitchens' matter on Mr. Salazar. And I'm sorry, to the clerks, could I have the file on Salazar? I think you may have received that back by mistake. Yes.
Judge, is it possible to see if maybe my client got, I don't know if he got kicked off. He's not in the breakout room anymore.
Let me see where he is. Yes, I don't see him in. Norma, can you have the jail find out where Mr. Dominique Hernandez is, please?
Yes.
Thank you. All right, we're going to proceed in Salazar. Let me find it. Oh, there's no file, right? Thank you. Court is calling NYMAG number 618564, State of Texas versus James Ross Salazar. Can I have parties announced for the record, please, for the state?
Hunter Morris.
For the defense?
Barry Hitchings, attorney for James Ross Salazar. We're ready on the motion to modify bond restrictions in NM 618564, Your Honor.
All right, and are you Mr. Salazar? Can you unmute, please?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objections from the defense?
No objections, Your Honor.
Mr. Salazar, do you have any objections with us proceeding by video?
No, ma'am.
Defense, I'm sorry, state, are you ready to proceed on defense's motion?
Yes, Judge.
All right, defense is your motion. You may start.
Now I call as first witness Cassandra Lopez.
All right, Ms. Lopez, if you'll start your video, please. All right, and for the record, the court appointed attorney Stephen Gilmore to represent Ms. Lopez as a witness. Mr. Gilmore, did you have a chance to confer with state and defense with regards to the facts or allegations in this case?
I have, Your Honor.
And did you have a chance to confer with Ms. Lopez?
I did, Your Honor, and I advised her of the potential criminal consequences for her testimony today, as well as some other collateral consequences that could result via CPS or other potential consequences.
All right, and is your client going to testify in this cause?
She intends to testify against the advice of counsel.
All right, Ms. Lopez, if you could raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you can state your name for the record, please, and spell your first name.
Cassandra Lopez. My first name is spelled Kassandra.
All right, defense.
Okay, may it please the court. Ms. Lopez, my name is Barry Hitchings. You and I have talked before, have we not?
Yes.
Okay, and you are, you and James are the mother of I guess he's 1.5-year-old son, Joel Salazar. Is that correct?
Correct.
Okay. And in our motion to modify bond restrictions in paragraph number 4, I recite that you and James' 1-year-old son, Joel Salazar, has been hospitalized for COVID-19 in the San Antonio North Central Baptist Hospital. Is your son and James's son still hospitalized?
Not no more.
Okay, so where is he now? Is he back home?
Yes, he is.
Okay. You also had informed me that James Salazar's father, Ronnie Salazar, was dying of COVID-19 in the San Antonio Downtown Baptist Hospital. Do you know what the status of James Salazar's father, Ronnie Salazar, is at this time?
At the moment, he is in, they already moved him out of ICU. They took him off the tube, and right now he's just recovering from COVID.
Okay, but he's still hospitalized, is that correct? And is that still at the San Antonio Downtown Baptist Hospital?
Correct.
Yeah, and I suspect James is anxious to see his father and son or somehow to communicate with him.
Correct.
Your understanding? Okay. You had submitted an affidavit to the Bexar County Criminal District Attorney's Office concerning the unauthorized use of a motor vehicle case. Do you remember doing that?
Yes, I do.
Okay, and did you make that statement? Is that in your own words?
Yes, it is.
Okay, I didn't tell you what to put in it.
No, sir.
You decided to tell the truth as you saw it. Is that correct?
Yes.
Okay, and I don't have the affidavit, but you had provided me with a first page of a statement that you were going to turn into the district attorney's office. You remember leaving that with me?
I do.
And I recite the contents of that statement in the motion to modify bond conditions filed with the court. You don't have that copy of an affidavit with you, do you?
I do not.
And what you left with me didn't have the notary page. Is that correct?
Correct.
Okay. But do you remember saying that I, Cassandra Danielle Lopez, date of birth 10/8/97, am the one who stole the vehicle that my husband was charged for? He had no idea the car was stolen when he took off in it because I didn't tell him it was stolen. Me and my husband split up for about a month, and when I came back home with the stolen car, again, my husband, James Ross Salazar, DOB 4-14-97, did not know the car was stolen because I told him I bought the car from someone when I really stole the car. I am guilty of stealing the car. You remember saying that in your affidavit that you signed in front of a notary public?
I do.
And that same affidavit you presented to the Bexar County Criminal District Attorney's Office.
Correct.
Okay. Is what you said in that affidavit true and correct?
Correct.
Okay. Do you recall how you came to acquire the car?
I was walking, I don't know whereabout I was. I was under the influence of pills, and I was walking, and it was super hot. I would say I was walking for about an hour, and I came across keys on the floor next to a car, and I picked them up. I opened the car door with the key, and I tried it on the vehicle, and the vehicle started, and I took off in the vehicle.
Okay. And were you and James separated at that particular moment in time?
Yes, we were.
Okay. And where was James living?
He was living with his mother.
Okay. And where were you living?
I was living at my grandmother's.
Okay. There was the unauthorized use of a motor vehicle that was filed. Do you recall how James got possession of that motor vehicle?
The officers, when the incident happened with me calling the cops and falsely accusing him of hitting my son, when that incident happened, he took off in the car, and he had went back to the park to go and pick me and my son up, and the cops were already there. So when he took off in the vehicle again, the cops saw him driving the vehicle.
Okay. And he was apprehended for unauthorized use of a vehicle. Is that correct?
Correct.
Okay. The incident you were talking about, that is an injury of a child case. Is that correct?
Correct.
And that involved you making claims that James Salazar, the father of the child, struck the 1-year-old Joel, I think you said 5 or 6 times, with his hand on the right side of Joel's face?
Correct.
Okay, is that true, or is that a statement that's not true?
It's not true.
Okay, so you did not see James Salazar striking his son Joel on his face?
No, I did say that.
Okay, but you did not see
I'm sorry?
Salazar striking your son Joel on the face?
No, I did not see
You
him.
may have said that, but you did not see that.
No.
Okay, that's what I need to find out. Your son Joel, there's some pictures the DA is going to ask to be admitted. There is a little kind of mark on to the side of his right eye, little kind of scratch. Do you remember seeing that scratch?
I do.
Now, how did your son Joel get that scratch?
The night before, he had fell through a broken chair that he was playing with.
And that's how he received the scratch by his right eye?
Correct.
Okay, I noticed in other photos below his lower lip, there looks like a little scab from an older injury. Did he get that from the night before falling through the chair?
Correct.
Okay. And do you recall, you told San Antonio police officer that your son Joel was struck by his father, James Ross Salazar. Is that correct?
Correct.
And then that is not correct. And at the time James Salazar was driving, and this vehicle was a Kia Forte, is that correct?
Yes.
At the time he was driving the vehicle, he was not aware that it was stolen, is that correct?
Correct.
And James did not have anything to do with driving the vehicle from the location where you found it?
That's correct.
Okay. Now, the injury to a child case, do you know what happened on that?
I'm sorry?
The injury to a child case on your son Joel. Do you know what happened to that case? If you don't know, you can just say you don't know.
Appears to be frozen on the screen.
I noticed that also, Your Honor.
She just zoomed out, so just give us a moment for her to zoom back in and we'll continue.
And Judge, just for the record on this hearing, to the extent allowed and necessary, I would invoke the rule.
Okay, rule is invoked. And Mr. Hitchens, while we wait for your witness to return, will this be the only witnesses that you're calling?
It will be, Your Honor, unless the defense surprises me, which I don't anticipate.
Okay. All right, as soon as she zooms back in to the waiting room, we will bring her back. There is someone joining by the name of Cynthia Salazar, so I'm assuming that's someone else.
Yes, Salazar. Don't recognize that name right off. Oh, I think, Your Honor, I hear my law partner say Cassandra. I think she may be trying to call my office phone.
Okay.
So,
All right, if you want to check that to see.
Your Honor, that was,
Yes, Mr. Hitchens?
yes, that was Cassandra Lopez. She said that her Wi-Fi had disconnected on her. She's trying to get back in. I told her we would wait for her.
All right, well, we will wait till 5 p.m.
Okay.
Well, I mean, just so Brenda, I see the smiles on everybody's faces. The court will conclude at 5 p.m. today. So if I will give her till 4:45, and then if she's not back in here, we will conclude with this tomorrow. And what time will that be, Norma?
Barry, she should be able to walk outside and use her cell signal and not the Wi-Fi.
Okay, hold on. Let me tell her to do that.
Brenna, you okay? I saw you shaking your hands.
Just habit.
Yeah.
She's trying to get on. She said her hotspot went out completely. I'm not sure what that means. But she says, okay, she's getting on now. Apologize for the inconvenience for everybody.
Oh, no need to apologize. We're here. Everyone has patience in their pocket. We take it out as needed and share it among the group.
Well, I remember earlier, Judge, you were telling everybody to have patience. So.
Oh, you have to. You never know what the day will bring. And at the end of the day, if you're angry about something, is that really going to change what is happening now? So you might as well make sure that everyone has a pleasant day. All right, Jason DeLeon, you're back.
He's done, Judge.
All right, Mr. DeLeon, you're excused. Cynthia Salazar, who are you with?
Oh,
It's me. It's Cassandra Lopez.
Ah, so you need to show your video.
Yes.
Yeah.
We don't have a video.
I don't know why it's not working.
Let's see.
It's not working now.
What does it say? Start
Mute my audio, start video.
voice my audio.
You're in complete darkness.
1 second. We're trying to get it on.
Are you on a phone?
No, I'm actually on the laptop.
Does it have a camera?
Yes, it
Oh,
does.
yeah, you gotta get it out of here.
No, it's not that. It's
Sometimes you might have to slide the screen on top. I forgot to do that one time.
It takes a village, people. It takes a village. And she is gone again. So I hope everyone can be back here tomorrow.
Resume at 9, Judge.
We're probably better starting at 11. That way we can take it up right away and you won't have to wait for other witnesses.
I can be back at 11.
All right, so we're going to pick this up tomorrow at 11. Is that okay for you, Mr. Hitchens?
That's fine with me, Your Honor.
All right, so we'll conclude, we'll start the conclusion of this hearing tomorrow at 11. Mr. Salazar, the court coordinator has already ordered you, so we'll be back here at 11, okay?
Thank you, Judge.
You're welcome.
God bless you.
Oh, thank you. God bless you too.
All right, thanks so much, Norma. If you can make sure to copy me on the Zoom invite, I'll be here.
Yes, Mr. Gill, I will do that.
Thanks so much. May I be excused?
Yes, thank you so much for filling in. I appreciate it.
Appreciate y'all.
Thank you.
Wait, it looks like she's back on.
Yeah, I was about to say.
Oh, it's 4:47 p.m. Somebody posted a meme and the meme says, no, court reporters do not want to work through lunch and they definitely don't want to work through dinner.
Okay, I won't hold you up. Thank you.
All right, thank you, Mr. Salazar. Norma, can you let them know L13 can go back?
Judge, Brenna, Hunter, y'all take it easy. I'll see y'all tomorrow.
what the hell is going on?
So what happened?
Oh, I'm sorry.
No, you're not sorry. That's just who we are.
The video.
We'll see you tomorrow at 11. All right, everyone. Mr. Hitchens, I'll see you tomorrow at 11.
We're excused then. Okay. Thank you.
Yes, thank you. All right, everyone, we are going to stop the live stream. And we will be back tomorrow at 9 a.m. I do not have to do juror qualification, so we will start tomorrow at 9. But it's Happy Wednesday.